What's up everyone, and welcome back to the channel. Today we're diving into the bizarre world of legal precedents that make absolutely no sense. I'm talking about the 50 dumbest court cases that actually created real laws we have to live with today. From lawsuits over psychic powers to legal battles about the definition of a sandwich. These cases prove that our justice system can sometimes produce the most absurd outcomes imaginable. Some of these will make you laugh, some will make you angry, and all of them will make you wonder how we got here. Well, before we jump in, hit that subscribe button and ring the notification bell, because we're about to go on a legal journey through the strangest corners of American jurisprudence. And stick around until the end, because the top 5 cases are absolutely mind-blowing. Well, let's get into it. Cases 50 through 41, the property puzzles. Case number 50. The haunted house isn't really haunted. As Stambovsky versus Ackley, New York, 1991. A buyer purchased a house only to discover after closing that the seller had been telling everyone for years that it was haunted. She'd even given interviews to Reader's Digest about the ghost living there. The buyer sued to get out of the contract. The court ruled that the seller had to disclose the house's reputation as haunted because she'd created a stigma that affected property value. This created a precedent where sellers in New York must disclose if a house has a reputation for being haunted, even though ghosts aren't real. So now haunted is legally a material defect in property, right up there with fountain cracks and mold. Case number 49. You can't own sunshine. Pra versus Moretti, Wisconsin, 1982. A homeowner installed solar panels, then his neighbor built a house that blocked sunlight to those panels. The solar panel owner sued for his right to sunlight. The court ruled that people have a right to sunlight for solar energy purposes, creating complex solar access laws. Now, in some jurisdictions, your neighbor can legally prevent you from building on your own property if it would block their solar panels. You don't own your airspace or the sun, but your neighbor kind of owns both when it comes to their energy bills. Case number 48. Trees have property rights. In multiple states, disputes over trees have created bizarre precedents. In one case, a tree's branches extended over a property line. The neighbor cut them. The tree owner sued for the full value of the tree, $20,000. Courts have ruled that trees are property, and damaging them can result in their full replacement value, even if only branches cross property lines. There are now certified arborists who testify as expert witnesses about tree value. An oak tree can be worth more than a car, legally speaking. Case number 47. The Spite Fence. Wilson versus Handley, California, early 1900s. A property owner built a massive fence, not for privacy, security, or any practical purpose, but purely to block their neighbors' view and annoy them. This created spite fence laws in multiple states. Fences built with malicious intent rather than legitimate purpose can now be legally ordered removed. Courts now have to determine the psychological motivations behind fence construction. Yes, judges have to figure out if your fence is mean-spirited. Case number 46. You own the air above your property, but not really. United States versus Cosby, 1946. A chicken farmer near an airport sued because military planes flew so low over his property that the noise killed his chickens from fright. The Supreme Court ruled that property owners have rights to the airspace above their land, but only to the extent that they can use it. This created the bizarre legal contempt that you own the air above your house, but only up to a certain height that courts decide on a case-by-case basis. Airlines can fly over your backyard, but a drone probably can't. Case number 45. Beach access battles. Multiple cases in states like Oregon and California have established that beaches below the high tide line are public property, even when surrounded by private land. Wealthy beachfront owners have tried for decades to claim exclusive beach access. Now, there are laws requiring property owners to allow public access corridors to beaches, creating situations where strangers can legally walk through portions of private property. The public trust doctrine means the ocean belongs to everyone, creating endless litigation about where exactly private property ends. Case number 44, the neighbor's wind. In several agricultural states, disputes over wind turbines created precedents about whether you can block wind that would otherwise reach your neighbor's wind turbine. Yes, wind ownership is apparently a thing courts have to consider. Case number 43, hot dog stands and fixtures. In New York, a hot dog vendor sued over whether their cart was a fixture attached to public property or personal property they could move freely. The ruling affected how street vendors operate citywide and whether they needed additional permits for equipment that touches the ground versus equipment that remains mobile. Case number 42, the Christmas display dispute. Multiple HOA cases have established that holiday displays are protected speech, creating complex rules about when associations can and cannot restrict decorations. One case involved a 50-foot inflatable Santa, and courts had to decide if size limitations violate First Amendment rights. Case number 41, noise ownership. In various nuisance cases, courts have had to determine what constitutes unreasonable noise and whether sound waves constitute trespassing when they cross property lines. Some jurisdictions now have laws where loud noises are legally considered a form of invasion, creating situations where your neighbor can sue you because sound waves from your property entered theirs. Cases 40 through 31, the food fights. Case number 40, is a burrito a sandwich? White City Shopping Center versus PR Restaurants, Massachusetts, 2006. A shopping center leased space to Panera Bread with a clause preventing other tenants from selling sandwiches. When Qdoba wanted to move in selling burritos, Panera sued, claiming burritos are sandwiches. The court ruled that burritos are not sandwiches because sandwiches require 2 slices of bread, not a single tortilla. This created legal definitions of food categories that now affect commercial lease agreements nationwide. Law schools literally study the legal definition of a sandwich. Case number 39, the hot dog debate. Following the burrito case, similar disputes arose over hot dogs. In some jurisdictions, hot dogs are legally sandwiches. In others, they're not. There's no national consensus, creating a patchwork of state laws about whether a hot dog is a sandwich, which affects everything from food truck permits to restaurant licensing. Case number 38, Subway's bread isn't bread. In Ireland, a case ruled that Subway's bread contains so much sugar that it legally cannot be classified as bread under Irish tax law. It's confectionery. While this case didn't create U.S. law, it highlighted how legal definitions of food can be widely different from common understanding. Case number 37, the pizza exception. Congress passed a law in 2011 declaring that pizza sauce counts as a vegetable serving in school lunches. This wasn't technically a court case, but it came after lobbying from food companies fighting nutritional requirements. Now legally, if a pizza has 2 tablespoons of tomato paste, schools can count it as a vegetable serving. Case number 36, tomatoes are vegetables. Nix versus Hedden, 1893. In a dispute over import taxes, the Supreme Court had to decide if tomatoes are fruits or vegetables. Botanically, they're fruits, but the court ruled they're vegetables for trade purposes because people eat them like vegetables. This created legal categories for produce that contradict biological reality. Tomatoes are legally vegetables despite being scientifically fruits, affecting law, regulations, and food labeling to this day. Case number 35, frozen pizza standards. A case established that frozen pizzas must meet specific legal requirements to be called pizza. There are federal regulations about cheese percentages, sauce distribution, and crust thickness. If your pizza product doesn't meet these standards, you legally cannot call it pizza. You have to call it pizza-like product. Case number 34, the boneless chicken wing case. A customer sued after choking on a bone in boneless wings. The defense argued that boneless is a cooking style, not a guarantee of no bones, and the customer should expect possible bones in chicken. Courts have been inconsistent on this, creating confusion about whether boneless is a promise or just a description of preparation method. Some jurisdictions now require disclaimers that boneless wings may contain bones. Case number 33, Coffee Temperature Wars. Liebeck versus McDonald's, 1994. The famous hot coffee case where a woman was severely burned by McDonald's coffee. While often mocked, she suffered third-degree burns requiring skin grafts. She initially only wanted medical expenses covered. McDonald's served coffee at 180 to 190 degrees Fahrenheit, hot enough to cause third-degree burns in seconds. The jury awarded damages and McDonald's lowered their coffee temperature. This created industry-wide standards for hot beverage service and warning labels about hot contents that now appear everywhere. Case number 32, the cocktail onion tariff. In a bizarre import dispute, courts had to determine whether cocktail onions are a processed food or a fresh vegetable for tariff purposes. The classification difference meant thousands in tax implications. They ruled cocktail onions are processed vegetables, creating precedent for pickle produce classification. Case number 31, chocolate content requirements. Multiple cases have established minimum chocolate content for products labeled chocolate. If a product falls below certain cocoa percentages, it must be labeled chocolate flavored instead of chocolate. This has created detailed FDA regulations about what can legally be called chocolate versus chocolate flavored. Cases 30 through 21, the animal antics. Case number 30, emotional support Peacock. While not a single case, multiple incidents of people trying to bring exotic emotional support animals on planes led to a new FAA regulations. The Peacock incidents in 2018 at Newark Airport highlighted the absurdity, even leading to restrictions that only dogs can be service animals on planes. This followed years of people claiming emotional support animals, including pigs, monkeys, and miniature horses. The new laws had to specifically enumerate that animals are and aren't acceptable. Case number 29. Can you patent a mouse? Diamond versus Chakrabarti, 1980, opened the door to patenting life forms. While the case involved bacteria, it led to Harvard patenting a genetically modified oncomouse. Courts ruled that modified organisms can be patented, creating the bizarre reality that someone can own a patent or on a living creature. Case number 28. Dogs are property. Even your emotional connection doesn't matter. In custody disputes after divorce, courts consistently rule that dogs are property, not family members, despite people's emotional attachments. Judges have to divide dogs like furniture, not using best interest standards like with children. This has created weird precedents where the person who paid for the dog usually gets custody, regardless of who actually takes care of it. Some states now have a pet custody laws, but in most places, your dog legally has the same status as your couch. Case number 27, veterinary standard of care for exotic pets. Cases involving veterinary malpractice with exotic pets establish that vets aren't liable for the same standard of care for unusual animals as they are for dogs and cats. If your snake or iguana dies due to vet error, your legal recourse is more limited because exotic pets have different legal standards. Case number 26. Wildlife doesn't belong to anyone until you capture it. Pearson versus Post, 1805. A hunter was pursuing a fox when another hunter killed it and took it. The pursuer sued for theft. The court ruled that wild animals belong to no one until physically captured or killed. Simply chasing an animal doesn't give you ownership rights. This precedent still affects hunting laws, establishing that intent to capture isn't the same as actual possession. Case number 25, dangerous dog breed restrictions. Multiple cases have upheld breed-specific legislation, where certain dog breeds are banned in cities or require special insurance. Despite scientific evidence that breed doesn't determine danger, courts have allowed localities to ban pit bulls, Rottweilers, and other breeds. This created a patchwork of laws where your dog is legal in one city and banned 2 miles away, not based on behavior, but appearance. Case number 24, Circus elephant rights. The Non-Human Rights Project brought cases arguing that elephants should have legal personhood and habeas corpus rights. While courts rejected giving elephants rights, the case created new discussions about animal legal status, leading to regulations about elephant treatment in circuses. Case number 23, horse boarding liability. Equine activity liability laws in multiple states were created after lawsuits from people injured by horses. Now, in most states, signs warning horse activity risk provide legal protection to stables, even in cases of negligence. You can sign away your right to sue if a horse injures you, creating a special category of liability exception that applies to no other animal. Case number 22. Cat hoarding is a crime. Sometimes. Cases against animal hoarders had to establish what number of cats constitutes hoarding versus collecting. Courts have ruled that it's not about quantity, but about care standards, creating subjective legal definitions of when cat ownership becomes illegal. Case number 21. Goldfish rights equal animal cruelty. In California, a case established that making goldfish fight each other constitutes animal cruelty. This created specific laws protecting even the most basic pet fish from being used in fighting, with criminal penalties that can include jail time for fish fighting rings. Cases 20 through 11. The workplace weirdness. Case number 20. Saggy pants can be dress code violations. Multiple cases upheld employers' rights to enforce dress codes, banning saggy pants, even when employees argued it was cultural expression. Courts ruled that appearance policies don't violate civil rights if applied consistently, creating workplace fashion laws. Case number 19. You can fire someone for being too attractive. Melissa Nelson was fired by her dentist's employer because his wife felt threatened by Nelson's attractiveness. Nelson sued for sex discrimination. The Iowa Supreme Court ruled in 2013 that firing someone for being too attractive doesn't constitute illegal sex discrimination. This created precedent that irresistible attraction is a legal reason for termination, even when the employee did nothing wrong. You can literally lose your job for being too good looking, and it's not illegal. Case number 18. Dreadlocks aren't protected. Multiple federal courts have ruled that employers can ban dreadlocks because hairstyles are immutable, changeable, and aren't protected under race discrimination laws, even though dreadlocks are associated with black culture. This created a controversial precedent that cultural hairstyles can be banned without violating civil rights laws, though some states have since passed the Crown Act to override these rulings. Case number 17. Mandatory fun is legal. Courts have upheld employers' rights to require attendance at team-building events, holiday parties, and social gatherings, even outside work hours. Refusing to attend mandatory fun can be grounds for termination. This established that your free time isn't entirely free if your employer decides company culture requires your presence at the bowling alley. Case number 16. Napping at work isn't disability accommodation. An employee with a sleep disorder requested permission to nap during breaks as a disability accommodation. Courts ruled that sleeping at work isn't a reasonable accommodation, even for diagnosed conditions, because being awake is an essential job function. Case number 15. Religious exemptions for beards, but only sometimes. Courts have inconsistently ruled on religious exemptions to no beard policies. If you're Muslim or Sikh, you might get an exemption. If you're Christian but claim your beard is religious, probably not. Courts have to determine which religions legitimately require beards, creating theological legal precedents. Case number 14. pregnancy discrimination through neutral policies. Young versus UPS, 2015. A pregnant delivery driver requested light-duty accommodations that were provided to workers injured on the job but denied to pregnant workers. The Supreme Court ruled this could constitute discrimination. However, the complex legal standard create means pregnant workers would have their employer accommodated others in similar positions, making pregnancy discrimination cases incredibly difficult to win. Case number 13. You can be fired for Facebook posts, even off-duty. Multiple cases establish that employees can be fired for social media posts made on their own time, from their own devices, about topics unrelated to work. Unless you're discussing unionization, which is protected, your social media activity isn't private, legally speaking. This created a precedent that your off-duty life can be grounds for termination if your employer decides it reflects poorly on the company. Case number 12. Drug testing based on profession. Courts have upheld drug testing requirements for some professions while striking them down for others. Teachers can be randomly drug tested in some states. Office workers generally cannot be. This created a tiered system of privacy rights based on your job. Case number 11. Weight discrimination is legal. Unless obesity is classified as a disability, requiring medical proof of an underlying condition, employers can refuse to hire or can fire people based on weight. Courts have consistently ruled that weight discrimination isn't illegal unless it's a symptom of a protected disability. This means your employer can legally decide you're too fat to represent the company, and you have almost no legal recourse. Cases 10 through 6. The privacy paradoxes. Case number 10. Your garbage is public property. California versus Greenwood, 1988. Police searched through someone's garbage left on the curb without a warrant and found evidence of drug trafficking. The defendant argued this violated Fourth Amendment rights. The Supreme Court ruled that once you put trash on the curb, you have no reasonable expectation of privacy. This means police can search your garbage without warrants, creating the legal principle that garbage is public property the moment it leaves your property line. Case number 9. License plate readers don't violate privacy. Courts have ruled that automated license plate readers that track vehicle locations don't violate privacy rights because you have no expectation of privacy in public places. Police can build massive databases of where your car has been without warrants. This created precedent allowing surveillance of millions of vehicles, tracking citizens' movement without individualized suspicion. Case number 8. Employers can read all your work emails. Multiple cases establish that employees have zero expectation of privacy in work emails, even personal emails sent from work computers. Employers can read everything without notification, creating a complete surveillance exception for workplace communication. Case number 7. Social media content is permanently public. Once you post something on social media, even if you delete it, even if your account is private, courts have ruled that it can be subpoenaed and used as evidence. There is no take-backsies online. This established that the intent is forever, legally speaking, and anything you post can and will be used against you in a court, even if you removed it immediately. Case number 6. GPS tracking requires a warrant, but cell phone location data doesn't always. United States versus Jones, 2012, ruled that attaching a GPS device to someone's car requires a warrant. However, cell phone location data has different standards. Courts have been inconsistent about whether police need warrants for historical cell phone location records. This created a bizarre situation where the type of tracking technology determines whether your rights are violated, not the act of tracking itself. The top 5. Peak legal absurdity. Case number 5. You can sue yourself and win. Orman versus Orman, 1979. In Utah, a woman driving a car was involved in an accident that killed her husband, who was her passenger. As the executor of her husband's estate, she sued herself as the driver for wrongful death. The court allowed the case to proceed because she was wearing two legal hats, one as the executor and one as the defendant. She won money from herself, or more accurately, from her insurance company, creating the bizarre legal principle that you can be on both sides of a lawsuit. This case established precedent that legal roles can be separated from individual identity, meaning that you can literally sue yourself and collect damages in certain circumstances. Law students studied this case wondering how anyone thought this made sense. Case number 4. Psychic powers are legally real for tax purposes. Several cases involving psychics and tax deductions created weird precedents. In one case, a psychic successfully argued that fees paid for psychic services were deductible business expenses because the IRS doesn't determine spiritual validity. More absurdly, the state of Pennsylvania recognizes psychic as a legitimate business requiring license. You can get an official license to practice psychic services, and the government doesn't verify if you actually have powers, just that you pay the fees. This created the bizarre legal reality that the government collects taxes on psychic services and issues licenses for mystical abilities without ever determining if those abilities exist. The law essentially says psychic powers are real enough to tax. Case number 3. A corporation is legally a person with religious beliefs. Burwell v. Hobby Lobby, 2014. The Supreme Court ruled that closely held corporations can have religious beliefs and can refuse to provide insurance coverage for contraception based on those beliefs. This established that corporations, legal fictions created on paper, have constitutional rights to religious freedom. A business entity with no brain, no soul, and no consciousness can have sincere religious convictions that override federal law. The legal principle that a corporation is a person for constitutional purposes has been expanded over decades, but Hobby Lobby took it to new extremes. Your employer's religious beliefs, as determined by its owners, can now limit your healthcare options. This creates absurd situations where the religious rights of a legal fiction supersede the healthcare rights of actual humans. Case number 2. The prison escape that wasn't illegal. People v. Whipple, 1997, California. An inmate escaped from a minimum security prison work detail, walked away from custody, but then immediately went to a courthouse to file an appeal about his case. He argued he didn't intend to permanently escape. He just needed to get to court. While he was still convicted, the case highlighted bizarre ambiguities in escape laws. In some jurisdictions, if you escape prison due to immediate threat of harm, fire, imminent violence, it's technically not illegal if you turn yourself in immediately after the threat passes. This created the weird legal concept of justified prison escape in certain circumstances. You can break out of prison legally, you just have to have a really good reason and give yourself back up quickly. Several cases have established that inmates who escape during emergencies and turn themselves in weren't guilty of escape charges, creating the paradox where leaving prison isn't always illegal. Case number 1. Frozen embryos are children, sometimes. Property, sometimes, or neither, sometimes. This is the most legally inconsistent, ethically complex, and absurdly handled issue in American law. Multiple cases have produced completely contradictory rulings about the legal status of frozen embryos. In Davis v. Davis, Tennessee, 1992, a divorcing couple fought over frozen embryos. The court ruled that they were neither persons nor property, but interim category, deserving special respect. The person who didn't want them to become children won. In Evans v. United Kingdom, a British case with U.S. parallels, a woman wanted to use frozen embryos after breaking up with her partner. The man refused. Courts ruled the man's right not to become a parent superseded the woman's right to the embryos. But then in 2024, the Alabama Supreme Court ruled that frozen embryos are children under state law, making destroying them potentially murder. This immediately shut down IVF clinics in Alabama because doctors could be criminally liable for discarded embryos. So legally, frozen embryos are children in Alabama, special category property in Tennessee, medical tissue in other states, or all of the above depending on context. This has created absolute legal chaos where the same biological material has completely different legal status depending on which state you're in. You can transport frozen embryos across state lines, and they transform from medical tissue into children just by crossing a border. Couples who divorce with frozen embryos face legal battles with no consistent precedent. Some courts say the embryos go to whoever wants them. Others say they go to whoever doesn't want them. Others split them like furniture. The law is utterly incoherent on this issue. This represents the peak of legal absurdity. Courts creating completely contradictory precedents about the same exact thing, leaving everyone confused about what the law actually is. Conclusion. So there you have it. 50 of the most absurd court cases that created laws we actually have to live with today. From sandwich definitions to the legal personhood of corporations. From garbage privacy to frozen embryo status. Our legal system has produced some truly bizarre precedents. The really frustrating thing is that many of these cases started with legitimate questions, but ended with answers that create more problems than they solve. When courts have to define what a sandwich is, determine if burritos are sandwiches, or decide if frozen embryos are children, something has gone very wrong. Some of these cases are funny, some are infuriating, but all of them show that the law isn't always logical, consistent, or even sensible. It's created through individual cases, often with judges making decisions that seemed reasonable at the time, but created long-lasting weird consequences. If you've dealt with any of these bizarre laws personally, drop your story in the comments. And if you're a law student watching this, good luck on your exams. At least now you know some of the weird cases you'll be studying. If you enjoyed this deep dive into legal absurdity, smash that like button, subscribe to the channel, and hit the notification bell. I've got more legal content coming, including the craziest laws still on the book in every state. Thanks for watching, and remember, the law is whatever court says it is, even when it makes absolutely no sense. I'll see you in the next one.